Any second hand? All those in favor say aye. Aye. Those against say nay. The ayes have it. Part 2, deleted. Honorable members, we go back to those areas where we stop payments and deal with those clauses one after the other. Beginning with of course clause 1. Clause 1.
Mr. Chairman, to be specific, yes. To be specific, I think it's 1B.
1B, yes, 1B. Yes. Yes, so what do you say? What do you say, Honorable Mary?
Okay. Again, Mr. Chairman, it's the issue of search committee. What is clear, 171.14 is clear about not being bound or whosoever. Do I have your attention, Mr. Chairman? The search committee is going to sit and make a decision. They will bring forward nominees to the president. But in this constitution, whatever the process, the consultation process, that might have taken place, subsection 14 of 171 makes it clear that it's not bound by the outcome of that particular consultation that applies. 53.3 is also clear on that. So why do we need to bring a group of people together, not for free at some point, spend all the time deliberating, make a decision? But at the end of the day, whosoever they are going to present this decision to is not bound by the outcome of that consultation. So, again, it's something like the operation was successful, but the patient died. The man you bring in this decision already has the power to implement that decision. So it is against this backdrop that we are saying, let the consultation process be clearly defined. In as much as, again, he's not bound by the outcome, so why take the powers from him when he can even reject? This is the question we're facing here. We bring them together, they make a decision, but when they bring it to the president, they still have the power to even reject it. So why not make them, again, we're looking for some other opportunity to bring people together. We spend resources, just like we're trying to ignore all the other resources or the time and effort spent on the previous consultations, the white paper. So let's not make it a habit of bringing people together. They make a decision, then at the end of the day, we walk away from whatever recommendation they brought. So what we have now is, we have even all the political parties who are not even part of the search committee. So what we are trying to do, to even politicize these other groups that will be speaking through to power. The sooner they have the opportunity to determine who conducts the election now, they automatically politicize. That's why we're going to start World War III. Who becomes a member of that particular committee? Because at the end of the day, they are going to determine the members. So again, we can prevent all of this, Mr. Chairman. He has the power. Let him make a decision in consultation with all the parties. I rest my case, Mr. Chairman.
Yes, Honorable Ekeke.
Mr. Chairman, a successful operation, the patient dies. Two things dissatisfied. The patient is satisfied that he was not abandoned when he was sick. Secondly, the family feel they done their best. What we seek to address is a democratic citizens will know there was a process that is credible. Is that too much to ask for? No. Politicizing the CSO, it should not be your worry. Besides, we have people who serve in the executive that we are CSOs. We are not politicians before they came in. Because somebody is telling us he has owned membership 15 years before he became PR. Let's go to the crux of the matter, Mr. Speaker. What we cease to do as a nation is correcting the very mistakes we've had, the very complaints we've had, election in, election out. Restoring the confidence of the people that their votes will count and their votes matters. Restoring democracy to the point that people will have confidence that when I get up in the morning 5 o'clock and I go to that queue, I am voting in the person that becomes the president. And the person who becomes the president has the confidence that I am leading the people that gave me their mandate. It's a social contract theory in which we give them our authority. They give us the social services. Therefore, we are not asking for too much. We are not saying the search committee nominates the president automatically. No. They are only part of the process to ensure we have a credible person in the office. Is that too much to ask for? No. But the trouble is, we already had a situation of consultation. Are we admitting that we very well knew it was done wrongly, and we were finding a definition for it all this while? We have a president that is so considerate, but yet still he could not do consultation for 8 good years in a manner accepted by the people of CNU. Are we living that again to the same situation of having him to define what consultation means for us? If we are supposed to beg, we beg for this. For the credibility of our process, for the credibility of our nation, for the acceptance of our results. Let us just allow the situation we are in. But I find it difficult to ask, what are we arguing over? As a chairman of a committee, a select committee, after doing everything, I report to the speaker, who is the arbiter and who is the head of this house. So my outcome at the committee stage, where I chair, where I should pretend as the speaker, is not finality until the speaker says so. So why is the speaker worried? Mr. Speaker, in terms of resources, if we want to save resources, let me say this. Even the people out there do not see us as worthy people to be paid. We can save resources by leaving this house and let the people have more resources. So I am saying my position is clear and our position on this side is clear. Let us save democracy. Let us assure the people of having an electoral commissioner that befits the status of our democratic credentials.
Yes. Of course, I know.
Our position on this other side was very clear, the true sense of patriotism. Make law not because they are sitting on the convenient side, with the interest on a normal temperature and pressure on all sides to have the financing for the good of this country. We have made our position. We are going to read that clause in the extant law. It's going to remain the same. And we ask that if there is any definition of consultation, we take it to the Public Elections Act, where we do the general administration law. Even this they are proposing, you cannot do the administration law in the constitution. You can take it to the Public Elections Act. It's fine. I don't want to go over and over what I've said. I have said the 10,000 number. What the president did for the appointment of electoral commissioners, I expect the times 2,000 number that go to the Supreme Court for interpretation. Or else, we stand with extra law. We are standing with the extant profession. I respect this. No more submission on this side concerning that. No more submission.
Yes, the leader of the opposition.
Ali.
I similarly believe that we've
Ali.
had ample debate on this topic. And no form of debate will shift anybody's position.
Ali, no, listen.
We profile him reasons for which we are against that very clause in the Constitution. And with all of the debates, if we still stand our ground, then I believe even if we open another debate, we'll be here for the rest of the year. So I want to pray from you, George, sir. You are the head of this house. I want to pray from you, George, sir, that we proceed with the process. Because it's clear. One of the reasons one of our members stated is that even when you define consultation and you have a sitting president who does not go by it, who will reprimand the president for not moving the Constitution? So being a job in futility. So we still stand our ground and we're against. We want that very clause to be non-merit and that commission is our position.
So, the leader of government business, can you state your position and move a motion?
Mr. Chairman, I have stated I have the protocol provision with me. Our provision, during we are in the opposition, presented the start committee as it is, rejected by the then government in 2017. Both the Peter Tucker and the Justice Kama, in blessed memory, both of them, as senators sustained the extant provision that was even 32 of the Constitution. Whatever definition we have to do, we address that in the Public Elections Act. I so move that we stay with the extant law.
Your position is that we stay in the extant law.
Yes.
Any seconder?
So second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it.
Olu, Ali.
Firstly, I want to rise on SO 46-1.
Order. All of you in the gallery. All of you in the gallery. Don't take part. You are citizens of the Republic of Sierra Leone. So you are right to be here. But you are not right to take part in what is happening here. Otherwise, I will withdraw your right and send you out. So please keep quiet and listen to what is happening here. At the end of everything, you can go to your members in their offices, you can go to their homes and tell them, SO2, oh, I like the way you talk today, but not here. Please, proceed, Honorable.
Mr. Speaker.
Sorry, leader, please.
Yes, Honorable.
Yeah, Mr. Speaker, my time is 12. Time is 12. So I move ISO 5 to suspend the business of the house.
Yes, any seconder? Any seconder?
ISO second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. Yes, leader of the opposition.
Yes, I rise on SO 46-1 to challenge your ruling, sir, and let it Mr. Speaker, this is about altering the Constitution, and I'll come to that. But firstly, I stand on SO 46.1 to challenge your.
Thank you very much, Honorable Leader of the Opposition. So I'm going to put the question again, and I'll rule. Yes, Leader. I'm putting the question again. Hold on.
Yeah, Mr. Speaker, before you put the question, my challenge is as a result of the fact that I am not convinced in the collection of voices.
Yes, that's why I'm putting the question again the second time. All those in favor say aye. All those in favor say aye. Those against say nay.
Ali.
Yes, proceed.
Honorable members, of course, you do not need to have a very loud voice. Because if it were that, they would have gone to look for those with the loudest voice to be elected in Parliament. Parliament is the house of procedure. We have seen and noticed that during the process, we have seen and noticed that during the process, there is immense participation from the gallery. Mr. Speaker, that is why I want us to have a head count so that we can have a specific number of members of Parliament who voted for and those who voted against. That is why I am standing again on SO 46.1 to challenge voice leaders.
Honorable members, a division has been claimed by the leader of the opposition. In the circumstances, I call both leaders to call their members who are outside to come in. I'm giving you 10 minutes to make sure all your members are here. 10 minutes. Sergeant at arms.
Yes, sir.
Sergeant at arms.
Yes, sir.
Clear the chambers. All strangers leave the chambers. We are already online. I will allow party executive members to stay on both sides. Party executive members, the chairman and their team, but all the strangers should leave the way. Leave the chambers. All strangers leave the chambers.
What are you doing?
In the gallery, we'll allow the journalists. In the gallery, we'll allow the journalists, for the reception of the journalists and the party stakeholders. All of you clear the way. All of you. We'll also allow the diplomats. We'll also allow the diplomats. Apart from those, clear. Go
Yeah, you don't see the material. No, the press will let. No, the press will let. No, we are not sorry for Gonado. The press will let.
The head of the press gallery, identify your members. The head of the press gallery, identify your members.
Hey! Buddy, hey! How are you going to pull it? Yeah. What are you talking about? Hey! What are you going to do?
If you're not supposed to be there, you'll be arrested.
Abala, what staff in a pull and do? Staff for what type of a pull? Don't want to get support. Officer, in a pull man. Come on, yes. Come on, go. Officer. Journalist. Madam President. All right. Let's just wait.
Hello, Madam President of the Press Gallery. Please identify all those that are seated that are not your members of the gallery. Just identify them. And I ask the security members to take them out of the chamber. If you know you are not part of that press gallery, leave the chamber. Mr. Get up and leave.
Prezo.
Parliamentary staff, leave the chambers with the exception of the sergeant at arms and the table clerks. With the exception of the sergeant at arms and the table clerks, all staff leave.
Yeah. No, they are there.
If you know you are not part of the press gallery, leave. This is the last warning.
Number one. Go back, go.
Honorable members, please resume your seats.
Declared by the leader of the Congress party, and in that regard, the Speaker has instructed for strangers to be taken out of Parliament, out of the Hall of Parliament, and strangers in that sense refers to members occupying the gallery, and of course parliamentary staff. But the Speaker also instructed that members of the press gallery should stay in the well, whereas members of Parliament will do head count voting. Members of Parliament will do head count voting on the section 32(3) of the amendment bill, which talks about a search and nomination committee to be set up. Already, members party voted and then the eyes insofar as this particular clause is concerned, the colleague gets to vote. So as it stands, members of Parliament from the Holy People's Party voted nay on section 33 of the amendment bill.
And if you are not a chamber staff and part of the
twice, both the motion was twice the motion was placed before the House, and twice they voted nay. Although they carried the vote in that regard, but the Speaker instructed, that vote by head count in the well of Parliament, and that is what we are yet to witness. In fact, the Speaker has instructed leaders from both sides of the political divide here to ask their members to walk into the well of Parliament to ensure that they cast their votes. And so voting, for viewers following on TV, voting is going to be done by head count, and the members of Parliament from across the political divide are going to, be upstanding from their seats, and they will be counted by the Speaker, and then the voting will be recorded. So we are yet to witness that.
Well, unfortunately, this is a very strict parliamentary procedure. Normally, in votes of this nature, we don't allow strangers to be around. Because I will allow the leaders, all political leaders, to occupy the diplomatic gallery. Please, leave this area. I'll allow you to occupy the diplomatic gallery. All parties take over.
So the Speaker has just instructed earlier on that party executives on both sides of the political divide, from the SLPP and the APC party executives and diplomats, will stay in the well. But the seats they were occupying was right in the chambers of Parliament. So the Speaker has instructed that the party executives should make their way now to the galleries, where they should witness the proceedings.
And former chairman, former secretaries. Honorable leader, this is my chamber. This is my chamber. I don't think you should be arguing like that. This is my chamber. And even for I think we had another vote. I think for the Auditor General, yes, we also sent everybody out. No. Okay, this time we don't want strangers within the way. They can go. That's why I told them to go. Please leave out your position.
Mr. Speaker, with all due respect, I'm appealing that you
Okay. Add to their numbers.
we have 5 from each group.
Okay, 5. 5 from either side. 5 from either side. Go up to the diplomatic gallery. 5 from either side. 5 APC, 5 SLP. Go to the diplomatic gallery.
Viewers, as you are witnessing live broadcast from the web of Parliament, the Speaker has also made another ruling that 5 members, each from the executives of both political parties, should make their way to the lower and upper chambers. So the Speaker has ruled that 5 members, each from the executives of both the ruling People's Party and that of the opposition People's Party, should now make their way to the lower, either the lower or the upper galleries, and from where they will witness the proceedings here this afternoon. You are still watching live broadcast, which you like on the Sierra Broadcast Television, and we are here in the well Parliament, where the final amendments are going to be made on the Constitution Amendment Bill 2025, which is in front of Parliament for the necessary amendment to be made. And then voting is going to take place on the relevant clauses in the said bill. Already, as you must have been following, there was a division in the voting process, from which the leader of government business read a motion out to the well of Parliament that the extant law on section 32(3) should not be included in the amended bill, which is to say to have a search and nomination committee that we select the chief electoral commissioner or candidates to fill in a vacant position of the chief electoral commissioner and other commissioners of the electoral commission for Sierra Leone. That motion was read to the House, in which members of the Unitary People's Party voted nay, and according to the ruling of the Speaker,
it is done for the security of members. We have seen in cases where people are shot, members of Parliament are shot for exercising their vote. Do you know that? In fact, at one point in time, recently, whilst we were on this debate, probably I didn't inform you, somebody was caught with a missile coming to the gallery. Somebody was caught with a missile coming to the gallery. It is for the security of members. This is not a secret society. It is just the security of the members. Yes.
Dear as you follow, the leader of government business approached the Speaker, pleading with him to allow executive members of political parties to remain in the world. But the Speaker has also just known that the reason and intent behind his ruling was for the security of members of Parliament.
And I don't see what's studying your ruling. I don't see what's studying your ruling. I was thinking of
Hold on, leader. Members, please sit down. Occupy your seats. All members. Occupy your seats. Yes. Yes. Yes.
I'm asking for you to revoke SO79. But if you can't manage SO79, you draw up all strangers.
We want 5 from the APC, 5 from the SLP, and 1 each from all the political parties. 1 each from all the other political parties. If you do not belong to this category, please leave. Yes. It's not about the forum again. In this case, it's about my ruling. I said 5 from either side, then 1 each from all the political parties. Of course, the diplomats can stay, and the journalists can stay. Former members of Parliament can go up the gallery. Former members of Parliament. Yes. So, Sergeant at arms, effect that.
Mr. Chairman,
Yes.
are we sure that all the journalists are accredited?
No, leave them, chief will leave them. Let me have the plan.
Yes, Chief Whip, you recall, Honorable Chief Whip, you recall that I drew the attention of the President to the effect that she has to identify those that are accredited to Parliament. For those that are accredited to Parliament, the list is with me.
And Sergeant Atan, tell your officers to occupy the entrances. Nobody comes in. Honorable members, like I informed you, a division has been claimed by the leader of the opposition. And in the next 2 minutes, we'll be taking the votes. In the next 2 minutes. Sergeant at arms, occupy the doors. Sergeant at arms, I'm seeing somebody using that entrance.
Who is that? It's closed.
Please clear the chambers, please. Yes, please clear the chambers. Go to the gallery. In the next 1 minute,
one of the contentious
we shall be taking the votes. Sergeant at arms, close all the doors.
For it to either be 18 or to be expunged from the amended bill.
We'll be taking the votes on the clauses. Just on the clauses. And we'll open the doors briefly for members, for you to relax yourselves. They will come to take the final vote on the bill. For now, we are dealing with the clauses.
The Speaker has also just announced that voting is going to be done on clauses.
There is a motion on floor
that we are under contention
by the leader of government business, and that motion has been seconded.
Voting on those clauses.
And the leader of the opposition has closed the division
of the bill
and has challenged the decision of Mr. Speaker. So we are going to the votes. I'm going to ask all those in favor to rise in their seats to be counted. After you have been counted, we also call all those against to rise in their seats and be counted.
So we are witnessing very interesting dispensation in our political trajectory. On that basis, we've just seen the Deputy Speaker of Parliament walking into the way because voting will soon commence. He has not been around since the proceedings started. We are just
honorable members, all those in favor of the motion of the leader of government business to the effect that the provision in the extant law remains and that the definition of consultation be done in another act. All those in favor say aye. Aye. Can you please stand in your place? Those in favor, can you please stand in your place and be counted? Mr. Clark. down, Mr. Clark. Sit down, please sit down. All those against the motion say nay. Please stand up in your seats. Please rise in your seats and be counted.
That of the amendment are absent medical grounds. But they stand confident. They stand confident that they will have their say. Although this certificate has been flawed, in which members of parliament are really going through a democratic process, ensuring that they do the needful.
Yes, Mr. Clark, can you report?
Amending this particular bill is concerned. We now wait for the announcement.
With the leave of Mr. Speaker, honorable members, the ayes 96, the nays 49.
In the circumstances, honorable members, the ayes have it. So the extant law remains.
Mr. Speaker,
Yes, I did have the position.
this is a very critical voting.
Ali.
This is
But you know what? You want the one to say, not able. You said good. You want able not to so. Not so the key. Tell me the chain and also the key. You don't know push go for too much.
Honorable, please keep your undertones. Because we
No,
want
you
the
are not push
public
go for too much.
to hear what we are doing here.
because, Mr. Speaker, the committee stage is very critical. In fact, it is the stage that encompasses the real process of changing the constitution or amending the constitution. This is the stage where we delete clauses. This is the stage where we insert new clauses. This is the stage where we change the constitutional wording. This is the stage where we substitute previous provisions. This is the stage where we vote on the passing of those very clauses. And Mr. Speaker, Section 108 is very instructive. It says that for the amendment of the Constitution, so Section 108, which is an entente clause, specifically deals with the amendment of the Constitution. And Mr. Speaker, when you want to change is, you want to change at, you want to change a comma in the Constitution, it should be followed by 2/3 votes of members of Parliament. Mr. Speaker, let me go to 1089. Let me go to section 1089, Mr. Speaker. It's very clear. It says, section 1089, it says this section, in this section, a references to the Constitution include references to any law that amends or replaces any of the provisions of this Constitution, and B, references to the alteration of this Constitution or any chapter or section of this Constitution include references to amendment, modification, or reenactment with or without amendment or modification of any provision for the time being contained in this Constitution or chapter or section thereof, the suspension or repeal of any such provision, and making a difference, the making of different provisions in lieu of such provision, and the addition of new provisions to the Constitution or chapter or section thereof, and references to the alteration of any particular provision of this Constitution shall be construed, shall be construed likewise. So, Mr. Speaker, it is very clear that Section 108, which deals with the amendments of the Constitution, specific references to non-entrenched clauses in subsection 2 and entrenched clauses in subsection 3. Any amendment to this Constitution does not need less than 2/3 vote of this House. Any amendment. In fact, in this case, the amendment is very clear. It's very clear. Even when you make reference to the Constitution, Mr. Speaker, when you take any wording in the Constitution, even without alteration, you reference it in another act of Parliament, it should be supported by not less than 2/3 of this House. I have had various arguments, especially the one that relates to subsection 1 of section 91, which states except where it is stated, the voting of Parliament shall be by simple majority. But in this case, the exception holds, because we are dealing with section 108, which has to do with amendment of our government, which is the Constitution. So, Mr. Speaker, I take the greatest exception, and we on this side take the greatest exception on the fact that this Constitution should not be amended, or no clause must be changed, or no letter must be changed, or no sign must be changed, be it in committee stage or in third reading with less than 2/3.
Now listen to just one more position by the leader of government business, and I will rule. Yes, leader of government. Except probably you have more. Okay. Yes. Then I will listen to Honorable the leader of government business. I will listen to Honorable Kifam, Honorable Daniel Kruma. Okay. Then I will rule. Yes.
Mr. Chairman, based on my study, Mr. Chairman, yes. Based on my study in the House, I want you all to talk before me.
Okay, Honorable Kifam.
Yes.
Thank you, Mr. Chairman. Mr. Chairman,
Listening to the honorable colleagues, please,
very critical. So I was all about it on this side.
Listening to the submission of the leader of government business, we all have to acknowledge that we are making law. This is not engineering. And in making law, you look at the text of the very law that guides the lawmaking that you are making. I refer you to the very section that you made reference to, section 108, subsection 2, and we read it carefully for the public to understand. Thereafter, I will take my seat. Mr. Chairman, honorable members, section 108, subsection 2, which my colleague has acknowledged, that deals with non-entrenched clauses, state thus: a bill for an act of parliament under this section shall not be passed by parliament unless a. Before the first reading of the bill in parliament, the text of the bill is published in at least 2 issues of the Gazette. That has been done, provided that not less than 9 days shall elapse between the first publication of the bill in the Gazette and the second publication, and B, the bill, this is the most crucial part, the bill is supported. It did not say the clause. It did not say the clause. Take note, emphasis 9. The bill, that is the entire bill. The bill is supported on the second and third reading by the vote of not less than 2/3 of the members of parliament. My submission, Mr. Speaker, members of parliament, it is my submission that we are at the committee stage, wherein we are voting on clauses, clause by clause voting, and as such we are guided by the provisions in section 91(1) of the 1991 Constitution, which I shall read as well. Section 91 reads, no, the members of parliament that are following, when we are voting on clauses, we are not voting on the bill holistically. When we get at the point where we have to vote on the bill, I will concede to your point that it has to be a 2/3 majority. But now that we are voting on clauses, you go by 91, because a clause and a bill are different. My submission.
Before my intervention, I just want to ask a simple question to the honorable members' submission. Simple question to the honorable members' submission. The honorable member from Kailam. Just a simple question for the layman understanding and for the attention of the public, for the attention of all the Ghanaians in and out of this country. Just one simple question. Sierra Leone is made up of 14 districts. True or false?
Teacher. 14 provincial districts.
14 provincial districts. Sierra Leone comprises of 14 provincial districts. True or false? True.
Honorable members, please, let me crave your kind indulgence. This is a very serious matter. Please, I'll crave your kind indulgence. You know, when people debate on this side, and when people debate on this side, please let's pay attention so that we get the public to hear what we are saying. Please, it's a plea from me. Yes, proceed.
14 provincial districts constitute the nation of Sierra Leone. Simple question for the layman understanding. If there is border disputes in one of those districts, what a district, in one of those districts, by another neighbor in the country, of which during that district, members of our district bordering that neighbor country are being killed, are being maimed, are being raped. Is it a problem of Sierra Leone or not? Let's say for instance, Kwanedugu. I came from Kwanedugu and I represent Kwanedugu. Kwanedugu borders Guinea, and Kwanedugu is part of Sierra Leone. If Kwanedugu has problem with Guinea, and then the Guineans come and bombard citizens of Kwanedugu, rape the women of Kwanedugu, kill the people of Kwanedugu, is it a problem of Sierra Leone or is it a problem of Kwanedugu?
You want me to answer?
It's a rhetorical question. It's a rhetorical question. You can answer in your mind. And your conscience can answer as well. The problem of Kwanedugu is a problem of Sierra Leone. And His Excellency the President is President of Sierra Leone, of which Kwanedugu is a part. Mr. Speaker, on that premise, I refer you to Section 91.1. Section 91.1. It reads, except as otherwise provided in this Constitution, underline that exception clause. Except as otherwise provided in this Constitution, any question proposed for decision in Parliament shall be determined by a majority of votes of the members present and voting. Mr. Speaker, you are a lawyer from no mean standing, and the honorable member from Gadao is a senior, and he quite well knows that this provision, subsection 1 of section 91, has an exception clause as an opening statement. That opening statement is not for nothing. The drafters knew what they were doing by providing that exception clause. Mr. Speaker, you will also agree with me, including my senior debate, that in law, you have rules. Sometimes you call them general rule. You have general rule. And you agree with me that not all, but most of those general rules, some of those general rules has exceptions. There are exceptions to general rules. And in fact, apart from that, there's a third stage. You agree with me in the law of evidence. That in addition to general rule, having exceptions, you also have what you call exception to the exceptions. You have general rule, you have exceptions, and you have exception to the exceptions. Secondly, you agree with me. You agree with me that all exceptional clauses supersede the general rule. Exceptional clauses supersede the general rule. You agree with me? My senior knows that. That whenever you have exception, that exception is superior to the general rule. It's not affected by that general rule. It supersedes, it's more powerful, it's more superior, it's more potent than the general rule. Mr. Speaker, I want to know this. Mr. Speaker, honorable members, I read the provisions of Section 108. But before I read, I want to inform this House that Section 108 is clearly, unambiguously, an exception to Section 91.1. It's one of the exceptions to Section 91.1. A clear exception. It's very, very clear. Mr. Speaker, another exceptional clause in the Constitution is the law dealing with state of emergency, passing state of emergency. State of emergency gives exceptions. It gives exceptions to the powers of the president. The general rule sets limits to the powers of the president. It sets limits to the rights, the human rights of citizens and non-citizens residing in and out of this country. It sets limits. But Section 29 now came. You and I know that under Section 29, those general rules regarding your human rights, your right of movement, your right of speech, or this and that, the exceptions supersede those ones under 29. And the president has the power to overrule his general power stated in chapter 3. The president under 29 has the power to overdo chapter 3 of the Constitution dealing with basic human rights. You know that very well. Mr. Speaker, clearly, Section 108 is an exception. And I read, without further ado, I read paragraph B. Paragraph B of Section 108. I will first read the opening statement. Subject to the provisions of this Constitution. Subject to the provisions of this Constitution. When you say subject to the provisions of this Constitution, you can say reference to the provisions in 91.1. But 91.1 is part of the Constitution. Subject to that provision in 91.1. Subject to any other provision. But I will refer you to the provision in 91.1. Subject to that provision. Let us stand here. And then move. Parliament may alter this Constitution. Parliament may alter this Constitution. Of course, may. Because it is of the discretion whether to pass it or not. We have the supreme power under 105. You know that. May alter this Constitution. What constitutes alter? The verb to alter. Or the noun alteration. What do you mean by the word alteration? In this Constitution, any form of amendments, any form of changes, any form of importation from one to this one, or taking it to another, or taking it from one chapter to another chapter, no, it's best fit under chapter 2 rather than chapter 3. It's best fit under section 9 rather than section 1. That's importation. And even by modification. By modification, it says, but it reads now this way rather than that other way. It constitutes alteration. And that alteration points to single individual clauses, single individual provisions in each clause. It says that bill, the bill before us, the bill before us is supported by the second and third reading by the vote of not less than 2/3 of members of Parliament. Now listen. Now listen. Subsection 8. Subsection 8 of Section 108. For further edification. Subsection 8 of Section 108. It reads, maybe I will only stop to the opening paragraph so that I will go to the others. Or if you don't mind, I will read all. Please read it. Subsection 8 of Section 108. Speaker. Mr. Speaker, honourable members, subsection 8 of section 108. It reads, any suspension, alteration, or repeal of this constitution, other than the authority of Parliament. Thank you, Mr. Speaker. Mr. Chairman, I will start fresh. Any suspension, alteration, or repeal of this constitution, other than the authority of Parliament, shall be deemed to be an act of treason. Now I want you to pay careful attention to this one. That to suspend, to alter, to repeal, only Parliament can do it. So now we are dealing with alteration. We are not suspending. We are not repealing. We are dealing with alteration. This alteration now goes, in fact, on belief, goes further to say that even references alone, by just making a reference, to a particular provision of the Constitution, amounts to alteration. But I will read for education. References to this Constitution include, listen to this, references to this Constitution include references to any law that amend, replaces any of the provisions of this Constitution. I will repeat this one. References to this Constitution includes, underline the word includes references to any law that amends or replaces any of the provision of this Constitution. Mr. Speaker, without going further, when you talk about provision, a bill is not a provision. A bill cannot be described as a provision. Provision refers to individual clauses. Provision refers to individual clauses. Individual clauses. Mr. Speaker, honourable members, in fact, this one you don't need to pass again. You don't need to pass again to understand this mathematics. Let's say the bill has 9 provisions. 9 provisions. I've told you what provision stands for. A bill cannot be referred to as a provision. Provision refers to individual clauses in the bill. Now let's say for instance, you have 10 clauses in a bill. 10 clauses in a bill. And then you say, this is for layman understanding. You say, those bills gathered together needs 2 clauses. Those 10 clauses gathered together are called a bill, are being referred to as a bill. And until it is treated as a bill, before it requires 2 clauses. But on the contrary, those 10 provisions, in order to pass each, you just be a simple majority. Now let's go this way. The Constitution says you need 2 clauses. For the 10 clauses put together, you need 2/3. And then you are saying each can go by simple majority. So let's say now, we'll go to the first clause, number 1 clause, simple majority, passed. Number 2 clause, simple majority, passed. Number 3 clause, simple majority, passed. Number 4 clause, simple majority, passed. Number 5 clause, simple majority, passed. Number 6 clause, simple majority, passed. Number 7 clause, simple majority, passed. Number 8 clause, simple majority, passed. Number 9 clause, simple majority, passed. The last and final clause, number 10, simple majority, passed. And now you all come now together. So well, from 1 to 9, you need 2/3, and then the bill cannot pass 2/3. Thank you. Does it make sense? If you can go from 1 to 10 by simple majority, and then there's another bridge to cross, and that bridge now, the law says you need 2/3, and then you cannot cross that bridge. So why waste time? It proves that that is not the intention of the drafters at all. At all. Mr. Speaker, the word passed. The word passed. Am I protected, Mr. Speaker?
Proceed, Honorable Director.
Thank you, sir. The word in law, passed, in quotation, passed. You know what it implies? It implies finality. It implies finality. Finality. When a bill is passed, it means it has come to completion. It is now law. That's the legal meaning of the word passed. So let me ask you this question. How can you apply the word passed to a clause? Clause 1 passed, clause 2 passed, clause 3 passed, clause 5 passed, clause 10 passed. And then all put together, or 10 come together, they cannot get 2020, and then it's not passed. So the word passed in law cannot apply to individual clauses. Under section 108, the term in law passed cannot apply to individual clauses. Simple majority cannot apply to them. Because under section 108, they cannot be passed in the absence of 2/3. Let me tell you one. Mr. Speaker, section 108 is so selfish. Very selfish. Selfish. I've never seen a selfish clause or a clause more selfish than section 108. Selfish. So section 108 sees itself as so important. I am everything. Without me, you cannot live. And everything starts with me. Thank you, sir. Mr. Speaker, I refer you to subsection 3. Subsection 3, paragraph A. I will read the opening subsection and then I will stop at paragraph A. Subsection 3 of section 108. Subsection 3 of section 108. Paragraph A. but I will read Section 3 for better understanding. Say a bill for an act of parliament enacting a new constitution or altering, remember altering, any of the following provisions of this constitution. That is to say, now I will read it again because I want you to understand. A bill for an act of parliament enacting a new constitution, listen, or altering any of the following provisions of this constitution. That is to say, number 1, this section. Section 1. That is to say, me. If you are given 10 oranges to share between 9 people, if you are wise, what will you do? The first orange belongs to who? Me. And then I will share the rest. The first law of nature is Section 108, respect the law of nature. Me first. And when the act says this section, number 1, paragraph A, this section, it means which section? Section 108. And Section 108, paragraph B of subsection 2 of Section 108 is part of this section. This section. And then it goes to outline the rest, the others. But it starts with this section. This section includes all of Section 108, all. And what this section says, that is why I see Section 108 as jealous. He's very jealous of himself. Once Section 108 has spoken, Section 108 doesn't want any interference, no interference. This section now says, in paragraph B, say it is supported at the second and third reading by the vote of not less than 2/3 of members of parliament. That is part of this section. It is not part of the intent clauses with requiring referendum. No, it does not start there. It doesn't start. It started with himself first. I'm saying himself because I see Section 108 now as a human figure. Human figure jealous of himself and very selfish, and he will not tolerate anybody to tamper with what I have spoken. This section. Mr. Speaker, honorable members, in fact, this is for common sense now. For common sense. Our body is made up of so many parts. Our body is made up of so many parts. You have your hand, you have your feet, you have your stomach, you have your eyes, your heart, and the rest. At a point in time, the head, the eyes, the hands, they revolted against the stomach. They revolted. So when me as the hand, I walk, I use the pen and write. The eye says, in fact, I see, I direct you. The brain will say, in fact, I gave you the idea to modify, to make sure, to make sure it is appealing to your examiner or to your awarding contractor or to Mr. Speaker for approval. At the end of the day, when you get your salary, when you get your money, you buy food, only the stomach, enjoy something. So they rebel. The hand says, I will no longer work. The eye says, I will no longer see. I will rebel.
Mr. Speaker, point of order, please. My colleague, please. Mr. Speaker, Mr. Speaker, I know you are the president of this world. I want all of us to be mindful of the principle of filibuster. I think that is what my colleague is doing. When a filibuster in a legislative process like this is trying to delay the process of coming to an end of a particular process. My colleague has been conducting.
All right, you know it's deliberate. You know I'm allowing debate. It's deliberate.
No.
Because on this matter, when I rule, my rule is going to take care of all the other clauses. So that's why I'm allowing debate. Because when I rule, that rule is going to take care of all the other clauses. So it's deliberate, please. Yes, honorable.
Mr. Chairman, for the order of this House, I will not permit. For the order of this House, and for your respect, I will not permit. I will go ahead. These parts of the body went on strike for 4 days. On the 5th day, what happened? On the 5th day, what happened? The eyes became dim, can no longer see. The ear can no longer hear. The hand can no longer walk. The feet can no longer take the body from one place to the other. At the end of the day, they all appeal again. Say, Mr. Soma, please, we are sorry. We are sorry for what we did. We are ready to support you now. And then they supported. In the next 1 hour, the human figure started sweating profusely. And then energy reorganized. What I'm saying here, I'm making this illustration to prove to us that Section 108 is a human figure. You cannot divorce any part of the Constitution as being separate from the other. Touching one is touching all. Alteration of one clause is alteration of the Constitution. With the alteration of that clause will not only change, but the entire Constitution will no longer be the same. It will change. Mr. Speaker, the legal meaning of text, T-E-X-T. The legal meaning of text. Text include even a full stop. Even a full stop is a text. And changing a full stop to comma can change the meaning of that particular section. You agree with me? Changing a comma, changing a full stop, removing a full stop, and replacing it with comma can change the intent of the drafters of that constitution. It can change the overall meaning. Will change. Automatic. Even if the students will know that this particular clause does not mean the way it used to be. Based on the change of that text from full stop to comma. Mr. Chairman, honorable members, in my final submission, I present to this House that the bill before us is a package. The bill before us is a package. What do you mean by the word package? Package is a combination or inclusion or constitution of various segments. These segments come together and form a package. If one of that segments is removed from the package is no longer the same. I don't know anybody here who used to smoke. I don't know anybody here who used to smoke. Or who smokes as I speak. Or for those who used to smoke, or who smoke right now. In my days, we used to buy a cigarette package, Western. That Western, it has 24 segments in the package. 24 in the packet. 24 in the packet. You remove one stick from that package, it's no longer a full package. Can no longer be referred to as a package. It's not. If one is cut into half, one cigarette stick in that package is cut into half and then inserted again with half, the rest full stick, the one half stick, it's no longer a package because the package has been altered. Mr. Speaker, above all, we are here speaking our minds, speaking of what we know for posterity. And if we are 200 in this world, I want to inform you that there's a 201 person. There's another person that constitutes also 201, and that is who? Almighty God. We are here speaking our minds, speaking of what we know for posterity. And if we are 200 in this world, I want to inform you that there's a 201 person. There's another person that constitutes also 201, and that is who? Almighty God. Almighty God is here listening. And there's what we want God in us. God in us. You have God in you, your conscience. Our conscience knows very well that section 108, paragraph B of subsection 2 of section 108 cannot refer to clauses to be dealt with by simple majority. No. Each clause amounts to alteration of the Constitution and must be imposed. In the absence of which, Parliament may be abusing the powers given to it under subsection 8 of section 108. Because section 108, by subsection 8 of section 108, and misinterpret paragraph B of subsection 2 of section 108, it amounts to abuse of office. And it can even amount to treason as well. We cannot misinterpret. Otherwise, it will go against subsection 8 of section 108. Mr. Speaker, on that note, I must say that we on this side, we are for the Constitution. And we are not supporting any undue procedure that will misinterpret the provisions of section 108. The people of this country are listening to us, and they all support the true meaning of this particular provision. And it allows 2/3 majority to change anything. Otherwise, anybody can wake up one day and then just change anything with no issues. It will be easily abused by allowing simple majority. Simple majority can never apply to this section. And when I say this section, I mean section 108. This section applies to all, not to some people. And that's my case for that.
And then give my ruling on this matter.
Thank you. I've listened to my colleague on the other side, the Deputy Leader of Government Business. I'm the Deputy Leader of the Opposition, and I'm happy he happens to be a lawyer, and he's a long-winded lawyer. But I'm sure in the course of this process, he has not been paying attention. If he has been paying attention, he will be alive and equal. I am not attacking him, I'm just saying, please, you said a lot of things, please, today's not the day, please, today's not the day. Not paying attention is not an insult, it's not an abuse.
The Honorable Kalamu made some statements. But I said for your respect, let us respect you. You think I cannot respond? Something came in my mind, bad. That's what it's yes. But I said for your respect, I will let us respect you. That is the glamorous, and then that's not respect for you.
Thank you very much, Honorable Daniel. Remember, let's be careful.
Mr. Chairman, I will still stand by my words. I know not paying attention is not an insult. Not paying attention is not being attentive. Period. And this House called that in the course of the passage or the review of this bill, when we discussed Section 76, myself and the leader of the opposition, we were against the extension of the enactment of 12 months as the period specified in this constitution for a civil servant or anybody prescribed by this constitution to resign. However, Mr. Chairman, you asked for a vote, and we voted. And in that vote, we were defeated by simple majority, and a ruling was made by Mr. Speaker. Mr. Chairman, I have said this process is bent or depends on the fact that we have to be honest. This is the Constitution. The other document is a proposal, a bill, which is not the Constitution as provided for in Section 108. A proposal before Parliament can never alter this Constitution, whether it is dealt with clause by clause or not in the committee stage. It will never change the intent, spirit, and purpose of this Constitution until it gets to the third reading. Mr. Chairman, how can a proposal be treated and he has read? And I'm sure he understands subject, verb, agreement, he understands the subject, the predicate, and all. So he should understand the fact that the emphasis on paragraph B and the very subsection 2 of section 108 starts with the word the bill or a bill. How can a simple clause that is not in this Constitution and is a proposal that is presented before this House end up as a factor to change this Constitution before it's called in? It's never possible. So the drafters of this Constitution, they knew that the fact is you can do anything at any stage, but at the third reading, before it has the mandate of Parliament as provided for by subsection 1 of section 108, that Parliament may alter it. Before Parliament alter it, it must have the consent of 2/3 of members of Parliament at the third reading before it is passed into law. But how can a proposal at this committee stage form part of the bill? I heard him say that if you take a stick of Western, by the way, those of you who are very young, it's white packet, it has a horse, it has a red background. My mother was selling cigarettes. I heard his description of Western, and I will also draw his attention to 2 examples. The first is those that attended Jala University will tell you that they will sit in the first year, in the second year, and in the third year, but they will never get a degree until they pass the comprehensive examination. Mr. Chairman, those who are teachers and those who start to the NCTV exams before they have the opportunity of going to college, I'm sure somebody is there. You will pass all of your exams at Mitulagai or whichever of the NCTVA constituent colleges, but you will not have the NCTVA certificate that will qualify you for an application for any university until you pass the comprehensive NCTVA exam. So if he's talking about common sense, I think common sense should apply pari passu. Common sense should apply pari passu that a clause that is not in this Constitution, that is a proposal brought to us by a minister of government can never enter or have its way in this constitution until after the third reading. Parliament takes the vote off 2/3 on the bill as provided by Section 108. So for me, I see this long-winded, skilled conversation as a way to try to play to the gallery. And we have passed that. We have been on radios, public radios, national television. We have taken a debate at the magnanimity of Mr. Speaker, even during the committee stage when we are discussing clause by clause. You allow a debate also to ensue. I think that is sufficient. And Mr. Chairman, this House will continue to rely on a source of law, which is precedent. And the precedent has been taken on this bill. We have voted on a clause that forms part of this proposal. And that clause will not pass until in the third reading it is voted for by 2/3 of members of Parliament. That is when that clause that was proposed during the second reading will become a law for this country. Mr. Chairman, we rely on your wisdom and we want to progress so that we complete this process as fast as possible.
Mr. Speaker, honorable members, I can't really understand this story. What is before us is a bill. Mr. Speaker, what is actually before us is a bill. For you to pass, I am not going to read the provisions. You know, Mr. Speaker, I guess you read jurisprudence, Jurisprudence, you read that one. It's the logic, the origin, and the underlying theories of the legal systems. That is jurisprudence. I was at private college, I was a law student. It's a very difficult subject. I mean, that's why it's difficult to pass. I know that Mr. Thompson is around, and Dr. Wright. I know they are around. He must be watching us. Oh, Doc is here. Mr. Thompson, oh, yeah, yeah. And Ronald Wright will be watching us. The man who used to admire. I did some logic. In composition of a sentence, you have a word. Word constitutes what you call sentence. And sentences, when you constitute them, makes up what you have a clause. And those clauses make up sections. Those sections formulate to have what you call a bill. Simple. So science of philosophy is what we call jurisprudence. Science of philosophy. Science of philosophy. So I'm thinking that the interpretation, going around, merry-go-round, interpreting this, going through this, we are not new. It's not the first time we are amending this constitution. We have done it, simple majority, at the committee stage, clause by clause. Mr. Chairman, it's very clear to us, in this famous section 108 you are quoting, trying to confuse people, we cannot be convoluted with this whole thing. We can't. We can't allow you to confuse us. As I said, I know where they are coming from. And I see them giving us their back at the end of the ruling. This has to do with the future of this country. Bill is what we have. We are continuing to pass it. We said, for you to pass this one, the bill, it is a bill. The topic is bill. It has to take 2/3. We have done collection of voices in the second reading. We are now at the committee stage. We are now approaching the third stage where you are going to put questions. We do division and we come now to vote to get 2/3. For clauses, they are explaining. It's 91. Simple majority. We have done this times without number. Over and over. Sometimes these lectures can be very unpalatable to us. When you may go around without making a logical conclusion, you have failed jurisprudence. You have failed jurisprudence. Mr. Chairman, for us on this other side, I still sustain our position. People are explaining sincerity of the law. We have to express that one. This 32 we are talking about for the consultations for this, we want the instant provision to be maintained. That is the provision we agreed in June 2017. That was agreed upon. Like, let Justice Kawan's report, white paper, we have it here. You all know, we have debated over and over. So we are not filibustering here. We just want the people to understand. And what we are doing is not the origin. That's why I said jurisprudence. The origin. It's not coming from us. It's not coming from President Liu. It's coming from the former administration and also the late Pakaba of blessed memory. What we are doing, we want to put finality to this process. So I don't think if you are teaching law subjects and simple English, this is written B. And we said, I said, everybody are defined, clauses constitute what you call, put it into sections. Sections, all of these makes up a bill. So we are sanitizing this bill. But when you want to pass it into law, all this issue of alteration, no alteration, for now, it doesn't make sense. If you don't take the 2/3, it's no law. If you don't take the 2/3, it's no law. So, when we cleanse or sanitize the clause by clause, we are going to put a section to these sections, and you put a final question. That is why, even in the 2/3, you have to claim division. When we are at the second reading, you put the question, and we did collection of voices. No dissenting view. That is 46, and you have claimed 46. It's not a bill. We said clause. If you are talking about a bill, you should have talked about let us vote directly. We cannot underscore the integrity of anybody, but let us make some sense out of our submission or out of what we have in front of us. So, Mr. Speaker, as Honorable Deputy Speaker said, we don't want people to play to the gallery as if we don't know what we have debated for so long. I will stand here and speak over and over, but we want to put a logical conclusion to this business to make sure that what we have in front of us for now, we deal with simple majority based on passing this particular committee, the clauses we have in form of simple majority. We have settled all the provisions. I repeat myself where I take my seat. 108 says 2/3 for the collection of the bill for second reading and third reading. The bill, it said cannot pass it if you don't have the 2/3 majority. What we are doing now is the clauses we are amending, and the clauses have to do with 91. This is not the first time. If they doubt it, I also encourage them to invoke SO12 hands out. I'm not new to these things. We have dealt with them. Amendment of PPLC Act. We did amend clause by clause of this constitution. Let's go to the answer. That's what we have the records. President, we have amended this constitution in the 4th Parliament using collection of voices, even when people had dissenting view. The man you call to the assembly, with all due respect to him, SPP and Honorable Chairman Manjubadi are also said here as Deputy Speaker. They passed an amendment. The election of Speaker and Deputy Speaker, a collection of voices. When you mean they had Salim, we don't want to go 79. We don't want to go to the Hansard. But Mr. Speaker, Mr. Chairman, we are watching. What you are putting to the fore of this country is our sincerity of document we have presented to this House. That June 2017, we all accepted to sustain this provision, Section 32(3), that has to do with consultations of appointing electoral commissioners. Thank you, Mr. Chairman. Thank you for the response.
Honourable members, I'm going to take my time to explain the reason for my ruling. I will take my time to explain so that everybody is able to understand the reason why I will rule in a particular way. Please, we're all members of Parliament. Please take your constitution and turn to 91. Section 91, subsection 1 reads, Honourable members, in fact, this particular section is not even written in serious legalese. It's written in plain language. all of us to understand. There isn't much legalese here. 91 subsection 1 reads, except, it starts with the exception, except as otherwise provided in this Constitution, except the Constitution says otherwise, except this Constitution says otherwise, any question proposed for decision in Parliament shall be determined by a majority of the votes of the members present and voting. So everything we do in Parliament, all the decisions we arrive at in Parliament, except this Constitution says otherwise, will be by majority of the members present and voting. Now, because this particular section refers to an exception, I will tell you that there are exceptions in this Constitution. Now turn to section 29, subsection 3. Turn to section 29, subsection 3. Section 29, subsection 3, particularly B, but I will read the entire section. Every declaration made under subsection 1 shall have A, I'm not bothered about A, but B. In any other case, sorry. Okay, in any other case, at the expiration of a period of 21 days, beginning with the date of the declaration, unless it has in the meantime been approved by or superseded by a resolution of Parliament, supported by the votes of 2/3 of the members of Parliament. That's one of the exceptions. One of the exceptions. You know, 91 subsection 1 says except. So one of the exceptions referred to in this Constitution is 29 subsection 3B. Now turn to section 119 subsection 9.
For the votes and proceedings. The references, I know the references. And maybe move the references.
Now, in section 119, subsection 9, honorable members, let me read. It says, the provisions of section 137 of this Constitution relating to the removal of a judge of the Superior Court of Judicature other than the Chief Justice from office shall apply to the Auditor General. Now, in this 119 subsection 9, reference is made to section 137. Go to section 137. Yes. Now, particularly subsection 7. Now, 137 subsection 7 reads, a judge of the Superior Court of Judicature shall be removed from office by the President if the question of his removal from office has been referred to a tribunal appointed under subsection 5, and the tribunal has recommended to the President that he ought to be removed from office. B, if his removal has been approved by a 2/3 majority in Parliament. That is another exception, tied up to section 119, subsection 9. There's another exception, section 137, subsection 10. Go to that provision again. Now, Section 137, subsection 10 reads, the Chief Justice shall be removed from office by the President. Now, A says something. B, if his removal has been approved by 2/3 majority in Parliament. I will also refer you to Section 173. Go to Section 173. Now, Section 173 reads, now the provisions, I'll take my time to read, the provisions of any consequential provision act made under this Constitution and of any act relating to citizenship shall not be amended, repealed, reenacted, or replaced unless the bill incorporating such an amendment, repeal, reenactment, or replacement is supported at the final vote thereupon by the votes of not less than 2/3 of the members of Parliament. Now, I'm taking my time to make reference, to refer you to all of these provisions, for you to know that apart from these exceptions, whatever decision Parliament wants to arrive at here is by the majority present and voting. Another exception is 108. Go to 108. Now go to 108. Now 108, subsection 2, particularly paragraph B. The bill is supported on the second and third reading by the votes of not less than 2/3 of the members of Parliament. Now, you see the law, especially codified laws that are written, you don't perceive them. You don't create your own perceptions about the law. Codified laws that are written, when the drafters want to say anything, they write it. I sense a whole lot of confusion about the Constitution. But when we come to the third reading of this Constitution, I will do a ruling. And that ruling will be referred to the Supreme Court for opinion. You don't create perceptions about the law. If the drafters mean anything, they write it. So apart from all of these exceptions, any decision we want to arrive at in Parliament is by the majority of those present and voting. All those now, honorable members, that being said, let me also refer you to the fact that this document we have before us, of course, the Deputy Speaker went to a very large extent to speak my mind. This document we have before us is not the Constitution. Because I sense a whole lot of confusion around this. It is not the Constitution. This document is not the Constitution. And this document we have is what we call a proposed law. It is a proposed law. And whatever we do in this document, line by line, clause by clause, does not affect the Constitution in any way. The only time this document is going to affect the Constitution is after it would have passed a third reading. Then all the provisions there come into play automatically. The day we pass the third reading of this document, that is when all the provisions in this document come into play. Otherwise, this is just a proposed law. It's just a proposal. This document is just a proposal. You know, the drafters were crafty enough. They were so crafty They know one important stage of this document is the second reading. Because after the second reading, then you go to, you're looking at the clause by clause, line by line, paragraph by paragraph. And they know at the third reading, then it becomes law. By dealing with any clause here, does not mean we are amending, we are repealing, we are replacing any provision. In the first place, this one we just dealt with is not even in the Constitution of Sierra Leone. This such a nomination committee is not even in the Constitution of Sierra Leone. So you can't even begin to talk about 2/3 or something that is not even in the Constitution. In the circumstances, honorable members, I rule that our decision, clause by clause, will be by the majority present and voting. Yes, leader of the opposition.
I so much respect you as a person. And my position has always been that we are living a lasting memory as a nation. This parliament is making the history. And we on this side, totally convinced, we are extremely persuaded that you cannot change east to worse and off to act in this constitution by mere simple majority. With every respect to your ruling, sir, as stated in SO 42, I want you and the general public, the entire world, to note that we on the side will not be a party to advocating or going against the standard of amendment. We have supported various reforms brought to this house. If we are not willing to support reforms, we will never have voted today. But what we did was an expression of our total willingness for government. But our willingness does not mean we should do what we consider as unlawful. So, Mr. Speaker, with all due respect, sir, pending on your ruling, we want the entire world to note that 96 honorable members of Parliament are seeking to amend a document that is to be amended by 100 members of Parliament. So we on this side cannot be a party to that, Mr. Speaker. So, honorably, sir, with all due respect, sir, I respect your office so much. I respect your office so much. And in fact, I am constrained because of the respect I have for your office. We on this side will honorably, with all due respect to your seat and with all due respect to this parliament and the people of Sierra Leone who are watching us, people all over the world, we on this side will not be part of an amendment that lacks the threshold of 2/3 majority. So on that note, we are leaving the ball in your court. 96 members. If you want to touch the constitution, you have the army.
predict.
For posterity.
No problem.
Posterity will hold you responsible. So on that note, I ask my colleagues on the side, I will take a peaceful leave and leave you and
I just wanted to inform you that yes, sir. The sitting is being disrupted already.
Yes, sir.
I missed you.
Yes, sir.
Yes, thank you.
Let's listen to yes. Okay. So we are going to start.
Honorable members, please occupy your seats. Occupy your seats. I'm going to be ruling. I'm going to be ruling on this subject, and I'll refer the matter to the Supreme Court for the opinion. Can we proceed with the other clauses? Proceed with the other clauses.
Mr. Chairman.
Yes.
Mr. Chairman, sir.
Go to the age thing on page 3.
Yes, page 3 on age. I think the aging made his proposal during the debate. Order, please.
Order.
Mr. Chairman, however, we have moved the age attached to whose qualification.
Sir?
I said, if we are putting a term of 2 years, of 2 terms, you should only qualify to be a commissioner if you attain the age of 65. If you attain the age of 65. We cannot use 2 bars in most legislations in conformity with the law for us to put two bars at the same time for one provision. So I'm moving that instead of, we said, he has not attained the age of 65 years, running down to B of that one, if he has not attained same provision under the member of the Electoral Commission, unless he has attained the age of 65. So we are saying,
okay, we leave it as it is.
You cannot be qualified. I have done 2 submissions.
So what do you
can only qualify to be a commissioner if you have attained the age of 65. That is one. But I'm going to introduce another clause.
Yes.
That he has a term limit.
A term limit
of 2 years.
Of 2.
Yes. So now
take note, Mr. Minister.
Mr. Minister,
can you move? Can you move?
Yes. To move that you cannot be qualified to be a commissioner if you attain the age of 65. That is one. That will come the rendition.
The rendition will be done properly. Any seconder? Any seconder?
I so second, Mr. Speaker.
All those in favor say aye. Those against say nay. The ayes have it. We proceed on page 4.
Mr. Chairman.
Yes.
We give you the rendition for. I want you to be consistent with other provisions like
of course. We have just passed it. We have just allowed it in principle.
In principle.
Yes.
So we come back to other rendition and we pass
yes.
it.
Proceed. Proceed.
Yes. So we come back to other rendition and we pass it.
Yes. Proceed. And okay, on page 3, there was this provision relating to if Page 4. If he is not a member of a registered political party.
That causes no harm. He just we put it just to enhance the process of legislation to qualify, yes, registered. What I think we have to do, because there is a clause at the PLC Act that has to do with a registered political party and an active political member. So we are going to put a registered political party. We will check that one with the drafter. Thank for the drafter is here. Okay. Because they are speaking in two different languages. So at a registered political party, I think we consult the drafter and we'll come back to that. But definitely we have to state it. Yeah, thank you.
Yes, Mr. Minister. Is that correct?
Yes, Mr. Minister. Yes. Again, while I agree, Mr. Chairman, and I'll mention first. Yes. Again, whilst I agree, Mr. Chairman, and I'll kindly plead with the Honorable Leader of Government Business. Whilst we're looking at that particular rendition, we also consider, because sometimes it's difficult for you to even do membership, we can talk about engagement in partisan.
Yes, page 4.
Chairman, I was expecting, Mr. Minister, we agree that if the masters for the qualification that if you have a postgraduate from a recognized university and has that is a chief electoral commissioner, unless he holds a postgraduate degree from a recognized university, 1, 2, and 2, has a professional qualification and experience in governance and public sector, at least for the chief electoral, at least 5 years.
Yes, we did that amendment.
We did that amendment, right?
10 years.
Yeah. Is it 10?
The
others are 5. And also for the bachelor degree, when you talk about postgraduate course in the chief electoral commissioner, you can act in that capacity at any time. So why not just say the same qualification for the electoral commissioner? For B, the electoral commission, unless he holds a bachelor degree of equivalent from a recognized, I think I want to be consistent with the law. For the SPSS, the qualification for the National Security Act, there is a difference in qualification with that of the NS score and deputies, even for CISA. So we said no. You can act in that position at any time. For the experience as you have done here, I can understand. But because you are going to act and that has to do with some level of efficiency and professionalism, I believe that that has to go to the level of qualification, that's of degree. I think they should have the same, for a consistency in enacting the law. Okay. That has been my position from what's the agreement submission to the House.
And under clause 3, we were supposed to have inserted 61. Amendment of 61.
Chairman.
Yes,
Chairman.
Yes.
Yes, I just want to make a quick comment on the recognized university aspect. So I don't know, there are some universities that are recognized, but then they are not accredited. So I don't know whether we say accredited or just recognized university.
Honorable member, before the chairman comes in, I don't think this is something we have to be labeled on, because we've had provisions that clearly spells out when it comes to the qualification in terms of how we use that particular aspect when it comes to universities. I don't think that will be a problem. Thank you.
Honorable members, I think we don't need to engage in further debates. Let's go to the issues as they are, because I don't think there is much contention right now. We just go to the issues and move.
Mr. Chairman, let's be honest. Let's just put this clear. We have
legislations currently exist for different institutions. They are part of, we have to understand, so we cannot come back to it. Of course. We cannot do the administration of the law. Of course. That is why we have other subsidiary legislations. But there is a reason I asked the minister for 108 in terms of fixed election dates. He made a pronouncement that yes, subsequently those legislation will be in front of all the PLC Act, the Public Elections Act, and also with the provision for the what do you call it, for regulations. So those things have been taken care of. The University Acts are there. Whether you are accredited, there's a whole lot of criteria you have to go through for it to be recognized as whether recognized university or not. What we are interested in, when we are doing our vetting, we now ask the relevant institution to prove to us whether you are coming from a recognized university or whether it's not no more university which you can accommodate. So those things can be dealt with. Thank you.
So we're on page 5, not so?
All right. Okay.
Yeah, of course, that one goes through. The rendition will now be done. As long as we've agreed in principle. Page 4, page 5.
Well, in page 4, the other day we discussed the issue of staggering when it comes to appointment. But the essence of that was not to allow the appointment to commence at the same time, to ensure institutional.
We agree.
Yes, but what's not clear, I think the terms. It came up. Yes, a commissioner shall serve a full term of 5 years from the date of appointment, irrespective of the remaining terms of other commissioners. That's the end of it. There is nowhere that talks about even reappointment. It's only a term of 5 years. So again,
that can be started by proper.
Yes, again, because you have that for another term of 5 years, like normally you understand reappointment.
Okay. That is on 4 also. Mr. Minister, take note of all of these issues.
Yeah, Mr. Speaker, I'd like to make some correction or something.
And AG, before, in fact, my attention has been drawn to it by the clerk that it was even inserted in that.
Yes, certainly.
Thank you.
Certainly, Mr. Minister. So we proceed to page 5.
Mr. Speaker, before we proceed to page 5, with your leave, because of the modifications that have been made, section 32, subsection 4, we propose that some rewarding is done, especially relating to the age of 65 years. And what I've gathered from honorable members, the intent is that if someone has gathered from honorable members, the intent is that if someone has attained the age of 65, then that person is not qualified to be appointed. Emphasis on the word appointed to Chief Electoral Commissioner. However, based on the submission that has been made and as approved by members of Parliament, if someone is already appointed for a term, and then in the course of that term, that person turns 65, he will still continue to hold that office until he or she finishes for that term. If he's a minister, deputy minister, member of Parliament, or a public officer, or if he has attained the age of 65 years. So which means, if under current law, if you turn 65 while serving on the commission, you cease to qualify immediately. So the proposal will be subsection 4 of section 32 to read, a person shall not be qualified for appointment as a member of the Electoral Commission, A, if he is not qualified to be elected as a member of Parliament, and B, if he is a minister, deputy minister, a member of Parliament, a public officer, or if he has attained the age of 60. If he is a minister, deputy minister, a member of Parliament, a public officer, or if he has attained the age of 65. So that way, that restriction, when you're 65, applies to appointment, not service. That would be the amendment. Mr. Speaker.
Yes, Mr. Chairman. So in that case, the issue of reappointment for such a person is null and void. Are we set on that?
Yes,
Are we set? Mr. Minister.
Yes, Mr. Speaker, we have taken note of the correction. We just wanted to provide that clarification.
Okay, it's all right. Yes, so we move on to page 5 also. Page 5. I think in page 5 it's the subsection 2 was where we stop in, which of course I strongly believe the leader on page 5. No, we don't have 2 on page 5. 3. Oh, B, I mean B. It is the B aspect.
Mr. Speaker, if I may.
It's the B aspect. Oh, yeah, sure.
Mr. Chairman.
Yeah, we deleted all of this.
Exactly.
Yes. Yes. So it should
agree to go with the instant law.
Yes.
Yes.
Thank you. And under clause 3, I think we changed 2 to 1. Yes. We changed 2 to 1 instead of subsection 2. I think under the proviso we did an amendment by the insertion of 61 or 61 or something like that. Am I clear on that?
Mr. Chairman, first let us do the amendment for the 30%. We're not getting a proper rendition, but we all accepted that we should have the 30% as enshrined in the Kiwi Act. So we should just import that one now.
Yes, that was what I agree. And I think there is something related to the executive. Not
yes, so we are here to have the minister.
You have to guide us.
Yes. Yes, Mr.
Just a minute, let me come. We need to have in a proper order. This one has to do with elections. This one has to do with electoral laws here. The one that has to do with the executive, we are saying we place it where we are 61. So it should be in the next page. It should be the other page. So for this we sustain 30% as the UB Act. Okay. So the thing I want Minister to clarify, is it going to carry the word shall as proposed?
Yes, Speaker Honorable Members, for
we still want to hear you on that.
For section 35, we will keep the word shall, and for section 61 will be made.
Okay. Okay.
So the submission.
That's on page 5.
Yeah. So your submission is still in line. Is still in line with only the 30% party nominees for national and local government elections shall be renewed.
Correct.
So the subsequent provisions in the Public Elections Act remain the same. We don't touch that one at all. Do you watch them?
Well, yes. The only thing is, when we get to that, we will propose an amendment to section 58 of the public elections.
So we don't need to go far. So if you accept this one, we now go to public elections and we do the subsequent amendment. Because you have said, I will also tell us to see in line with section 58 of public elections. So here we maintain the word shall, Mr. Chairman, and we rely on the Public Elections Act to entrench, to make a clarification in section 58. Okay, all right.
So is that noted?
Yes, sir.
Then we move on to page 6.
Mr. Chairman, please.
Yes.
I'm not a lawyer, I'm a lawmaker. I just want some clarification.
Oh.
Yes.
It's simple. One person representing. What is the difference between them? When can the president appoint without making reference to any group? One person from.
Where is that?
Well, Chairman, I think he's talking about his search and on the children.
No, we are done with that.
On page 5.
No, we are done with that.
Mention the language I'm talking about.
No, forget about the language. We are done with that.
Mr. Chairman, there is no way I intend to do the job, sir. Yes. But again, there are certain areas where we agreed on, so you understand, no need to reopen them.
Yeah,
just like you're drawing our attention to the areas where we stock pins, yes. And those areas have been highlighted.
Yes, page 6. Page 6.
Mr. Chairman, sorry, sir. I beg to differ. Those questions were not. Those questions were agreed on principle. So what we need to do for the identification of the public, we have brought in all of those provisions we seemingly agree. But it has no force of law. Yes. So we have to state it. Yes. It's either they have worked out that we agree on those provisions, on principles. So what you are doing now, we are taking our time to go close like you stop keeping on them. Yes. So I will now say we have dealt with all of them that
all
we
proposed.
61.
Yes.
Making term limit for electoral commissioner. And what you are proposing, I will say, attend it because we say you cannot put too far. The qualification should be the same. And the year of 10 years and 5 years. I remember yes. We agree on those things. Right. So we have to go over it so that people understand we agree on them.
Of course. So page 5 to 6. Page 5 to 6.
Page 5 to 6. There is an area, the top part of that's section 4. The A and B, there we stock pins. The C and D that had to do with the census, we are finding that. So it was the A and B aspect that we are going to look at because we're talking about the aging as well, talking about moving the constituencies in the certification aspect, the A and B, those are the areas that we stock pin. Okay.
So are we okay now with them? Because there is no much contention. You don't have much contention anymore. So are you okay with that? Leader of government business? 5 to 6?
Yes, I'm okay with that.
So those provisions stay? Okay. Mr. Minister, the provisions stay, not so?
Yes. Yes.
Page 6, page 7. We deleted the independent candidate, not so? Yes. Yes. And okay. So we are done with page 7. Page 8.
Well, it's clear that in page 8, E, that's where we have the issue of the treasury.
Yes, the treasury.
Yes.
But there is no more contention.
Well, the age.
Mr. Speaker, I'd just like to clarify. I think we made clear in this well that yes, in the bill, we had made a proposal for a threshold of a simple majority of total valid votes cast throughout Sierra Leone, and then to a minimum 20% of the total valid votes cast in at least 2/3 of the districts of Sierra Leone.
Well, I think you agreed on.
Yes. Yes, I just wanted to make clear to everyone including listening public, that we are agreed with the technical committee made up of the APC and government of Sierra Leone, that the amended bill on the floor of this house is to read that a person shall not be declared elected president of Sierra Leone unless at the presidential election he obtains a vote of 50% plus 1 of the total valid vote cast.
50% plus 1?
Yes.
Okay.
Of the total valid votes cast.
The total valid votes cast.
So, and that removes the threshold and simple.
So 50 plus 1?
Plus 1, yes.
Okay.
Plus 1.
Yeah, Mr. Chairman.
Mr. Chairman, this is in line with the tripartite recommendations.
Yes.
Chairman, so the one we have in the bill, and we have the tripartite, and this is in line with the white paper in June 2017. More than 50%. Everything is in line. So what we are seeing now, because tripartite is so recent and it's in conformity with the conditions, so we forget about the threshold, district threshold, and stick to 50 plus 1.
Yes, certainly.
Now let me be a little case for the public. If you go to section 42E of the Constitution, the first phase, the proposal we have, what is the extant provision, is 55%. And if there is a runoff, F of that provision, section 42, subsection 2F, saying it's going to be simple majority in 14 days, because you do elections in 14 days with simple majority. So there is very much difference, I see. But this one is more entrenched, it's more classified in terms of reaching out to other political parties. So some of us will receive another provision from PPRs, from APA, that there is a situation where you will not get the 50 plus 1. What happens? So we are saying for national inclusivity, because we have argued on that
of course, if the law says 50 plus 1, if you can't get 50 plus 1, then you do runoff. Then there is runoff.
So in a case where,
and in runoff, the one who scores the highest wins.
It is majority. So there is a proposal also that instead of going around doing runoff, what about making a coalition with other parties that will give me 50 plus 1?
That should be an individual candidate.
Yes, so you should not do runoff. That's what the proposal from the APA, from all political parties. That was the proposal. So if the AG, so we need to discuss it. Mr. Chairman,
yes.
Then the proposal from APA.
AG.
So if this house says,
is it not 50 plus 1, and in the event no political party scores the 50 plus 1,
Mr. Chairman,
yes.
Yeah, and Mr. Chairman, repealing this particular section by bringing in the tripartite recommendation, fair enough. We realize that tripartite recommendation, both parties were there, and the presence also of international community. It will be very fair enough to import tripartite recommendation to this bill now. And by repealing this today, I think we join the rest of the world. The entire ECOWAS, as a member of ECOWAS Parliament, I realized that right in this supplementary act, Article 4 subsection 2, is saying countries should endeavor to have uniform laws. I think it is only Sierra Leone that is still going 55% to make it president. But all of the ECOWAS countries, do your research, they are all 50.1 or simple majority. In fact, to the extent of even AU, 54 countries comprising the AU, all of those AU countries, they practice 50.1 or simple majority. So repealing this age-long draconic law today will help Sierra Leone to join the rest of the world. I so submit.
Chairman.
Let's proceed.
Mr. Chairman, I also just want to clarify that with this proposal and because adopting what the leader Parliamentary said, so this proposal, just to be clear, that yes, the 50+1 threshold, which will mean no person shall be elected as president of Sierra Leone unless at the presidential election he has polled a total of 50 plus a minimum, not less than 50 plus 50% plus 1 of the valid votes in his favor. And so the threshold which we see under 2 of that clause will go away completely.
Of course, we have stated that.
And
I think what the leader wants to know is in the event nobody scores 50+1. That regulation has to be done.
The government's position on this for now is in the default of a candidate being duly elected under the provision that I just read, the 2 candidates with the highest number of numbers of votes shall go forward to runoff.
More realistic.
All those in favor say aye. Aye. Those against say nay. Proceed. Page 9.
Mr. Chairman, just
page 9.
For neatness of proceedings, it's just clear that this aspect of the bottom part of page 8, way to the top part of page 11, we agreed to take all of that to the public elections.
That is very correct, Mr. Speaker.
Yes, all of that. Yes, so take all of that. So that should be the bottom part of page 8, page 9, page 10, also.
In fact, to the top part of page 11, just above clause 8.
Yes, we agree. Okay, thank you. Now, the remaining part of page 11. Yes, under this one, we said to which the state is a party, but we decided to remove that to say any critical.
Yes, to delete that aspect to which the state is a party.
No, not the state. We remove that aspect.
Yes, that's what I'm saying.
And we made it general.
Yes, sir.
Mr. Minister, take note of that. That's for page 11.
Chairman, can we get a clear text of this one that you are seeing?
We said in 43, in the event that the presidential candidate is standing trial on a criminal charge, you delete to which the state is a party. Delete that one, to which the state is a party. On a criminal charge 1 year prior to the election. So we just delete that as well. So it becomes general, whether private or state prosecution.
So we now say trial is suspended.
Yes. Yes, after 1 year. That's for page 11. Page 12.
Again, Mr. Chairman.
Yes.
Yeah, just a clarification. So this goes for purely presidential candidate, not their candidates.
Of course.
Fine.
Not presidential. Yes, page 12.
Page 12, remember the top part of page 12, just B, was deleted.
Yes, this one was deleted. Delete?
Yes, the top part, yes. And also,
we deleted 10.
In fact, 10 was the transitional provision, and we deleted 10 to the top part of page 13.
And we deleted president or
yes, because that provision has to do with the vice president, so the word president there was redundant.
Yes. Then under 12E, we deleted expulsion.
Expulsion was replaced with his removal.
So under clause 13?
Well, 13 at some point had a contention for some reason. Again, we can go back into the AG. We talk a bit on clause 13.
Yes, on 13. AG. We object to that. There is an insertion. Then we object to that. Yes, AD, that's it.
Sorry, Mr. Speaker. Can you please go over that? Can you please go over that?
Well, I was saying.
There was contention on the proportional representation.
Yes,
that was
plus 13. That was the only area where we stuck a pin.
Yes.
The other areas had to do with removal of the vice president, but the president was inserted and we deleted president.
Yes, we deleted.
Yeah, yes,
no, we are on clause 13.
So that, yes, I'm just taking it through.
Yes, Speaker. Yes, we keep the proposal to amend Section 74 of the Constitution to read B. Such number of members of Parliament as Parliament may prescribe who, subject to this Constitution, shall be elected through a system of proportional representation. And then we have included an additional link to say with a detailed mode, method of nomination and conduct of such elections prescribed by or under an act of Parliament. And Mr. Speaker, with your leave, I'd like to just provide some context on that.
Yes, please.
That additional link.
Yes,
yeah, that is what.
Yes,
that is what.
Well, of course.
So,
then what do you need to explain now? What do you need to explain?
So I'm just trying to provide. So of course we want to keep the name of that. The detailed mode and method of nomination be prescribed in a separate legislation. I think we're on the same page on that. I just wanted to say, if required, I'm happy to provide context on why we recommend that. But if members of Parliament, already have the context that such prescription will be made in a separate law, and we will have a conversation on such proposals. We are happy to leave the conversation on that.
Yes. So on page 14, page 15.
Mr. Chairman, on page 14.
Yes.
We stock a smaller thing, where, in the sense that we have to agree on the safeguards.
Yes, the safeguards. Have you done the rendition for the safeguards?
Well, to some point.
Yes.
Because
read them out.
One, with regards, we have to agree on something because at some point we'll have to revisit 41. We'll have to revisit 54 because 41, the qualification for president, 54, the qualification for president, also on that particular aspect. Then 56 to 60 ministers, then 75 to 77 members of parliament. And then, to some extent, even if possible, the Citizenship Act was put forward a consequential provision. So, now, we're going to settle on something because not less than 24 months, immediately preceding the date of nomination for appointment. All the safeguards, we talk about NASIT. And then also on that day, I also raised the issue of disclosure of all foreign citizenship. It was very important because if we consider you here as a dual citizen, we want to know the other nationality which you held again. Of course, disclose any foreign public office.
I hope Mr. Eddie, you are taking note. And Mr. Thompson is here also. Take note of all of those issues.
Yes, Mr. Speaker, we did take note of all of those, and I think we are on the same page.
Yeah, do a proper rendition to reflect that.
Mr. Chairman.
Yes.
Esteemed you have to do that. He made a lot of proposals that you have made.
Oh.
The chairman. So I was thinking I should have given us a new edition, putting in place like the layout, president, vice president.
You can use a legalese, instead of amending those, you can use the legalese to reflect the position in all of those sections you refer to. You know, notwithstanding what is in that, so something like that.
The new chairman,
yes.
You have to be very careful. Don't forget that there are other discussions.
Yes.
And this one we have to maintain a proportionality.
No, it's just the proposal I'm making, not that I'm making submission. I'm still in line with what you are proposing. But I want us to be clear on the text provided to us. If you read the text, it's very clear and voluntary on any declaration of allegiance. That is what we are doing. And that is what is in line, the spirit of why we are changing to 6-1. So if you categorize them as we started, with other categories, so being in line with other existing legislations, it can be fine. I don't want us to go too deep. Where it's, I mean, at the end of the day, if you're talking about to be legal association for voluntary, you want to be minister, you have to go and make an amendment. You know that very well, Mr. Minister. Oh, yes, I'm doing this. You have to make one amendment 56. So you have to accept it, we have to have a revision, and we go back for 56. Because you cannot be a member of parliament, you member of parliament as a minister. So we are making exceptions, we have to go for 56. If we want our brothers in the diaspora to be part of us, we have to be there, we have to be careful, we give both sides of the eye.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go proper revision.
We have to be there, we have to be careful, we give both sides of the eye.
What I mean, we have agreed in principle on all of these issues. But it is now for the draftsman to go proper revision.
I have a lot of people talking about what you told us. You don't want us too much to this one, like on any, and it was making it too naive for us to do those things in the constitution. What I'm just saying, we should be the principle that let us go back and look at them, we all agree, because this is not about us. This is about our own family members who are abroad, but has happened because as a son of our family. So what we said that we now look at the issue, with other legislation, so we cannot mix them up. So that when we come, we now put them properly. It is going to the constitution. So that is it.
Thank you. So, yes, all those in favor say aye. Aye. Those against say nay. The ayes have it. Let the rendition be done.
The clarification, Mr. Chairman.
Yes.
Yes, the rendition is going to be done. But I just want again to make it clear that I mentioned the four positions. Any others could fall into some of the legislation because I listed all. So let's really be clear on that particular aspect.
So what we have agreed when you do the rendition, make sure I see it.
Yes, again,
do the rendition and bring it. Let me see.
Why I'm going over this again? I mentioned the position, the president, the vice president, the speaker, the chief justice. The day I made the submission, there were some other positions, but again, the House never accepted it on some of those. But we have to bring, because I raised a point about the Inspector General of Police, the Chief of Defense Staff, and many more. So let's be clear that that day I made that submission, it wasn't accepted. So we have to provide safeguards where I talk about 24 months.
This is a position that was accepted on that occasion. It was unacceptable.
And in fact, I also, the honorable leader is basically there. I raised or I highlighted the provisions that we will revisit at some point, together with the draftment, of course, 54, 41, and then 56 to 60, and all the rest of it. Again, I don't know because
Mr. Clark, take note of that. Mr. Clark, take note of that.
Sorry, Mr. Yes.
Mr. Chair.
I think, Mr. Speaker, honourable members, I think for government in the submission last week, unfortunately, I left the piece of paper where we had proposed the rendition for Section 76. Look through my file; it's not here. But our proposal was to add a proviso under Section 76 to read as if a person, something actually, and I had worked on it, just don't have it. But we're basically saying a person who is a Sierra Leonean by birth, but holds the citizenship of another country, we put it in the context of dignity. It shall not be qualified to run for election as member of parliament unless that person has paid local taxes to the community for 5 years preceding their candidacy for such an election, and that person has been physically resident in Sierra Leone for a period not less than 24 months. And then we provided additional language to say that such a person shall not be qualified to hold office of president, vice president, speaker of parliament, and chief justice, because these are all positions in line with the presidency. Any of these persons can act as president at any time. But for the other positions that were suggested, I think, Mr. Speaker, honorable members, I laid out with concrete examples why we will design ourselves in ways that will affect us in the future if we attempt to extend such a restriction to other positions, including Chief of Defense Staff, Inspector General of Police, noting, as I said, that we have had foreign nationals hold these offices before, or that the Sierra Leone national has served as Chief Justice in another country before, although in that country their constitution doesn't provide for being in line to act as president. And then, of course, other examples about Governor of the Bank of Sierra Leone provided an example of the current Prime Minister of Canada, who was the Governor of the Bank of England, etc., etc. So noting that Sierra Leoneans by birth who will hold citizenship of other countries, but might have significant contributions to make to various sectors, and at a particular time when they might be the best fit to serve in these positions. Our submission, Mr. Speaker, honorable members, was that we should not restrict ourselves too much. But for government, we are very happy keeping these restrictions to the positions that we have highlighted, which is one, such a person will not hold the office of President, Vice President, Speaker, and Chief Justice. That will be our submission, Mr. Speaker.
Mr. Chairman, honorable members.
Yes, proceed.
We should also bear in mind that we amended Section 7 to allow all of us to serve as Speaker, and there is no way we are going to make a law to debar members of Parliament to become Speakers. Because, for instance,
not members of Parliament, who are citizens.
No, the fact that the person is qualified to be a member of Parliament, it should be qualified to act.
It's like saying a dual citizen can become the president.
It's like, why are we allowed?
Do you accept that?
If they are members of Parliament.
Oh no, do you accept it?
And it's the next section 78 of the Constitution. It said that members to be qualified speaker.
So you are against it?
Yes. So if you are a member of Parliament, you should be qualified to be elected as a speaker. Let
me understand something. So you are against dual citizens?
No, we are not. I am against the decision that members of parliament who are dual citizens should not serve as speaker. If they are qualified to be members of parliament, they should be qualified to be elected as speaker. They should be
The only reason why they do not want the only reason why they do not want them to become speaker is because it cannot be.
Mr. Chairman.
The only reason why they do not want. The only reason why they do not want them to become speaker is because they cannot be president. They cannot be president. And the speaker acts as president. That's the only reason. The speaker normally acts as president. The chief justice normally acts as president. As a matter of fact, I've acted as president over 7 times. You cannot have a dual citizen acting as president.
Then we can equally say let us not have them in parliament. But we cannot that will be defeative of section 78 as amended, sir. It will be defeative of section 78 as amended.
So what do you say?
Section 78 states, if you are coming from outside parliament, you should have served parliament for 2 terms. And if you are coming from within parliament, you should have served parliament for 1 term. If we now state that as a member of parliament you are not qualified to be elected as speaker because you have a dual citizen, how did you come to parliament? Your mere presence as a member of parliament qualifies you to be elected as speaker. Your mere presence.
No, Mr. Speaker.
Yes. Hold on,
Mr. Chairman, everywhere you walk, you have voluntarily naturalized and carry a dual citizenship. So we have to make critical decisions on behalf of the state. And we are acting as president in the 2 interests. So we don't even want to be, we are placed the bar. We are president and vice president. You can't be president. That is the optimal position. President and vice president. So we don't even want to act as president in that capacity. That's why we are putting chief justice and the speaker of parliament. Because you have acted, yes.
I don't think the people you are fighting for. I don't think they are fussy about that. Because the point, what I'm saying, the only reason why the speaker, the chief justice, vice president, those positions are being accepted is because you cannot be a dual citizen and become the president of the nation. It's a matter of allegiance. It's a matter of allegiance. It's a matter of allegiance. You cannot be a dual citizen and become the president of the nation. In fact, it's almost all over. It's almost all over. So if we have a unique situation in Sierra Leone where we want to bring our brothers in, then we can still bring them in with certain safeguards so that we don't compromise the security of the state. With certain safeguards. That's the only reason why.
If we have allowed persons who have dual citizens to serve in that position as ministers, to serve positions as members of parliament, leaders of government business, how can we now say we don't allow them to serve as speakers? Don't forget, ministers negotiate contracts on behalf of the state. They come into agreement on behalf of the state. So if we want to allow them to serve, it is like consequence of because they will get them to be qualified to be speaker, you should be qualified, you should be a member of parliament. How can you have a member of parliament and you not begin to draw the line between, you are just MP, to just MP, you don't qualify. If you are qualified to be a member of parliament, you should be qualified to sit in that position.
Hold on. We have this here, God, one salary for 3 minutes and it doesn't matter. So be president. We have this here to the world. There's no legal contract. Nowhere in the world, you know, not make ourselves funny. We are making it presentation funny. Are you saying they are American citizens or you are a citizen of Ghana, not to be a citizen of Australia? You are acting as a president. You are acting as a president. So, if there is submission, we continue to put restrictions on the seats. This is an exception. In other places, you cannot even be in America. You cannot even be a member of the police force. When you have one cities, you cannot even be a member of the police force. So they are bad. This is complete bad. That you cannot be president and vice president. The reason why they are bringing chief justice and the speaker, because they are acting in that capacity. Let me be realistic. These are exceptional clauses. They are ruled. They are not an hour ago. Exceptional clauses. We are not making it 76. So they accept. Yes, you can be a member of parliament, but it's under the domain of parliament and the president.
Yes, you want to be speaker. If you want to be speaker, you go and relinquish your citizenship. If you want to become speaker, then you go and relinquish. You know, so about that. You go and relinquish your Let me learn the chief whip.
Yes, as we have Mr. Chairman, I think I'll give you a
Yes.
They are showing a bar.
They should be a bar.
Come to Parliament to have execution. But you cannot try to become a speaker.
The speaker. If you want to become speaker, you will not put your citizenship wrong. Yes. The chief whip is still on the legs.
As long as there is a law,
yes,
you can come to Parliament, but you cannot try to be speaker. But even the president at that time,
yes, you can go and relinquish.
Exactly. That's why the second thing.
The chief is still on his legs.
As long as there is a law,
yes,
you can come to Parliament, but you cannot try to be speaker. Or even the president at that time,
yes, to be you can go and relinquish.
Exactly. That's why the second thing, Mr. Speaker. Let us not talk about having a local tax for 5 years. As I'm talking to you now, my daughter is in America. I have local tax for her for the next 3 years. So that's it will not work.
Yes.
It's not work.
There should be stringent conditions.
Thank you. You can get local tax even outside the country as long as they belong in that particular kingdom. So that way it's very flexible. But I agree with you and the leader and the speaker. When you want to be speaker of this party, because when you are a speaker, the speaker they are acting as president more than twice. We cannot have
seven times.
Thank you, 7 times.
I ruled you 7 times.
We cannot have somebody who has she become a speaker of parliament. When you want to be, you want to apply for speakership, you go and denounce your citizenship.
So, Honorable Bashir Siliki, I don't think that is
Mr. Chairman. Mr. Chairman.
If you hold on. You can be qualified to become speaker, but you have to, even if you are a dual citizen, before you become speaker, you have to go and relinquish. Because when you occupy that position, you act as president.
But Mr. Speaker, honorable members, I was a member of Parliament when we amended Section 78. And Section 78 reads, Mr. Speaker, of Parliament who have served Parliament for 1 term, or is coming from outside who have served for 2 terms. It is better we say, let us go back and amend Section 878 amended.
We cannot amend, we just say, Mr. Chairman, Yes. Okay, Mr. Chairman,
Mr. Speaker, honourable members, so the restriction, if you
hold.
Sergeant at arms, I told you to close the door, not so? That is simple directive. Close the door. Only members of parliament are allowed to go out and come in. Carry on.
So the restriction, just to be clear, if you are a Syrian by birth, but hold the citizenship of another country, the restriction is actually for the presidency. So, which means you are getting the right to participate in the politics of the country, but noting that you have a restriction to occupy the presidency. No, please. You have a restriction to act, to occupy the presidency. If you want to occupy the position of president, then you relinquish that additional nationality. Now, the reason why these other positions are coming into play, it's simply because these persons could act as president at any time. And so it is to ensure that if someone who is a Syrian by birth but holds the citizenship of another country gets into the political space, we ensure that that person does not act in the position of president. That is the only reason why Chief Justice and Speaker are coming in. Now, we do not need to amend Section 78, because while Section 78 there are very clearly persons who could be elected as Speaker, the restriction in 76 will apply if that individual wants to become Speaker. That is what this will mean. So we don't need to amend 76 because there is already a restriction in 76 which will apply to President, which will apply to Vice President, which will apply to Speaker, and which will apply to Chief Justice. That is what this will mean. Thank you, Mr. Speaker.
That's for page. Please, honourable members, I would rather want the leader of government business and the chairman legislative committee, or the leaders to take the lead, because you debated, all of you debated. Because now I don't want to open this thing to a debate. On this particular, what do you want to say on this matter?
No, Mr. Chairman.
We have read this.
Mr. Chairman.
Yes.
Yes. On this particular. Yes, sir. Mr. Chairman, I had the visit of the minister the last time. One of the Mr. Chairman, for a period of course. Yes, but when the new edition was pronounced, I didn't hear that.
No, that's what should be included.
Yeah. So it's still part of the
Of course.
Okay.
Yes, Honorable Bakari. 1 minute.
I think we are gradually getting entangled in this whole issue. So I am proposing that the best way to get ourselves out of where we are now is that maybe we maintain the extant law. So essentially, how could you discriminate against someone who has been an MP maybe for 2 terms and they are choosing to the position of
there is no discrimination. It's not a condition. There is no discrimination. You are free to become, but you have to nobody said on this matter. No debate. It seems there is confusion. Hold on. Yes. Honorable leader. Yes, let me hear you.
I therefore move on suspend SU5 so the business of the house will continue.
Any second now?
All
those in favor say aye. All those in favor say aye. Aye. Those against say nay. The ayes have it. Let's leader on this matter.
You see, I started seeing the bureaucratic provision. Genuinely, we want to amend 76.
Against say
It's really for them to come and be president. It's really to give them space to really participate in our process. The use of leverage. You know, I've not seen anywhere where you have clearly voluntarily declared yourself to be a citizen in another country. Everybody knows about you. And you are going to be a president. No, maybe after a president. So you need to be careful. It's a serious business. The AG has advised us. He's a legal advisor. No matter what you say. He said these are exceptions. He brought this amendment. These are exceptions. It cannot be. So we have to place some seriousness in the legislation. That's just that. So I appeal to my colleagues, even a deputy leader, that because we are not giving in, initially we don't access him to sit. We have to start somewhere. And even when I reminded him about his seat, he said he will now amend. When you do something, you take off his. So we are going to look at all these provisions so cannot be examined with the extant law.
We proceed. That's for page 14, page 15. Is it still on this point? Honorable Batu, still on this point?
I still believe we should amend section 78. I might not win, but let me just say this like official. And it should be yes. Section 78 was amended by all of us. This parliament, it was amended. I know, Mr. Speaker, Mr. Chairman, honorable members, when we came to this parliament in 2012, we had a lot of positives coming from the diaspora who were members of parliament. And after today, Mr. Speaker, nobody will question who has been or not. All of us will have to contest elections. Then people will have to contest elections, and they will come, and nobody will have to declare. Nobody will have to declare that the SOT did have to see over our. We are all here.
Part of section 78. Do you want amendment?
That is the qualification of the speaker.
Mr. Speaker.
It is amended. It is not.
Read section 78.
Section 78 read.
Read section 78.
Section 78 read. So it is not here. You cannot intermediate that.
Point of order. 34. The side note has to do with the High Court Landlord Association. Mr. Chairman, Mr. Chairman, our colleagues don't understand. Yeah. So no, Mr. Chairman, my colleagues don't understand. You know, you just want to when we push. Somebody said, if I never just maintain the internal condition, this really is to have our fellow citizens abroad to participate in the electoral process. But you cannot see I'm coming to be an American, to be something that want to be president, not to be speaker of parliament. That should be a bar.
So that you are almost always in America.
If you go, you're right. You're right. Because you're not citizen. You're right. Colleagues, the minister, one minute please. The minister has proposed for us. He has made the position very clear that let us accept the amendment and propose with an exception. Let us move forward. Our colleagues in the diaspora, I think what they propose, what I have from there, I have a text from them. That they even talk about if they have 5 years, nothing. Because all those things, they are never mentioned that you want to be president. If you want to be president, recuse yourself. Don't apply that my allegiance is gone. I'm now purely Australian. I don't have to do a citizen anymore.
That's what we are saying. But let a nation, beyond this function of Sierra Leone, let us see us as a serious legislator that we are putting a power presidency.
Of course.
This position when you are in here, nobody can stop you.
Yeah. Let the proper rendition be done, man. Let the proper rendition be done to that effect. That's for page 14. Page 15. Page 15. Let me hear you.
Yeah. Mr. Speaker, actually I'm pleading, and I'm sure our minister will agree with me. And I'm talking about where members are obliged to resign from public office at least 6 months before the date of election. Let me land, please. Give me time. No, we did not.
But we passed that already. Let me hear you.
Yes. Okay. Hear me, Mr. Speaker. Mr. Speaker, we have our, government workers, like the police, like the military, like the nurses, who intend actually to come to Parliament one day. And their salaries will not allow them to be asked to resign 12 months before
Page 15, page 16.
Page 16, Mr. Chairman.
Page 16,
let's
16.
I'm still on page 15.
Yeah, what is it?
Let's just be clear here, because again, top part where they mentioned the Anti-Corruption Act of 2008, we already.
Yes, proceed.
Yes, the page 15, just a reminder that we took from the mid to the bottom part of it to the Public Elections Act.
Yes, Honorable Committee.
Yes, if you can recall, starting from C, the AG members clarification, what you have in paragraph H, it was a mistake, it becomes paragraph E. So, again, Mr. AG, in page 15, just for the records. Remember, we had H, but again, you came up and said it was paragraph E.
Yes. Yes, take note of that, AD.
Yes, Mr. Speaker, Honorable Members, that is noted.
Yes, and the bottom aspect of it was moved to we agreed to move it to the Public Elections Act.
Correct.
That's for page 15 also?
Yes, 2.
Is that noted?
That's noted.
That was.
We dealt with all of these provisions.
Yes, no, it's the confirmation. We understand.
Okay, yes, take note of that.
Like you said, we were paid by page of the confirmation.
Yes, Mr. Minister, take note of that. Now, page 16
and page 15.
Yes.
Like just an clarification for the agency.
Yes.
We are talking about 2 plus 2. You talked about E. We're talking about election-related offences. Somebody being debarred for 12 months, a bit convicted for 12 months, and should not participate. We can the AG, because election-related offences is not, it will mean it's all big, it's not, you don't have no qualification for that. It can be minor, it can be major, it can be. So when it's
minor, whether major, as long as you have been convicted,
yes,
they should not qualify.
Mr. Chairman, like my argument here is we talk about the doctrine of charges or case against presidential candidates for political reasons or non-political reasons. So we can qualify that, both civil and political. Now, you now come to election-related offences, and we are all politicians. Somebody somewhere will just look at you at one point and say you committed XYZ because of Mr.
Let me talk to you on this. You see, when you make laws, these minute details about life you cannot put into law. If you want to take care of everything in the law, you will never end. It's a minute thing. You see, somebody can just come, redeem it, and they take you to court and they convict you. Put up a defense. You put up a defense.
Mr. Speaker, if I may.
Yes.
If I may, when we put disqualifiers in laws, it's only when they are established such, let us say for criminal conduct, if someone is disqualified for criminal conduct, it's only when that is established that they are guilty. It's not when somebody points to you that you've done this. It's only when you have been convicted.
You have to go to court and convict.
Exactly. And the point is, we have also included language to read that these are offences for which someone will serve jail time. Yes. These are not offences for which the sentences can be even substituted by fines.
Yes.
Again, if I may add, Mr. Speaker, honorable members, that can be corrected. Whilst I argued strongly that this provision is set in the Constitution, I think the leader of government business had moved that this provision, these proposals, be moved to the Public Elections Act. So I think where we ended with this was the removal of 2 from this bill. In any case, Mr. Speaker, I also want to add, I think I need to provide clarity on this issue of elections-related offences because I think the Deputy Leader of the Opposition raised the same issue. Actually, in the Constitution right now, when we see the extant law, yes, election-related offences are there. Yes. They're there. If you are convicted of fraud, dishonesty, or election-related offences, you will be disqualified. So basically, we were just expanding the scope. Right? We're just expanding the scope, but I think this House has resolved that this expansion be moved into the Public Elections Act.
Okay. Now, yes.
I understand that you say elections related offences. Let me cite an example. I was petitioned in 2018 election. APC won in the elections. I was waiting. Why? One of the grounds of the petition was there was a fight at the polling center and I was there. And to them, it was an election-related offense
that should have taken me out of this parliament because I was there and I was a candidate. So it is too late. Because as you are saying, Mr. Speaker, that even how small the offense is. When your opponent wants to go against you, and you are a strong force, they can bring allegations that and they can win in the court. We all know the court. So, I was going to be removed.
When you have your back, allow them to what is wrong now in the court system? There's nothing wrong to say no the court system. Nothing wrong. It depends on your opinion.
If you don't have evidence, you lose.
Mr. Minister, let me hear you.
I think, Mr. Speaker,
yes.
What of course the Public Elections Act, offences are listed.
Yes.
They're not big.
Yes.
Election-related offences are specific. If they are not outlined in law, you cannot be charged or prosecuted.
But I think this one is part of those laws.
Exactly. But also, Mr. Speaker,
you can raise that in the Elections Act.
Yeah, you can raise that, when you look at the sections that outline offences that are termed as election-related offences. But also, Mr. Speaker, I think we need to establish one day. Again, I say, when we last discussed these proposals, my understanding was that we settled on they moving to the activity to move them to the Public Elections Act. If it is the position of this House that these proposals be discussed in the context of the bill, then let's discuss them. But if it's the position of this House that these should go to the Public Elections Act, then I don't think we should be discussing them now. We can wait for the Elections Act.
Mr. Chairman, the reason why because he made a very salient point which there are reasons for some of these trials not to really state in the Constitution because we have to use them for conviction. The issue here is conviction. When they are convicted, you don't contest the conviction. That is clear. But the reason that I brought to you before why we should take the public elections, because I give on behalf of rape and sexual condition. And I said, that law, as I speak, we are supposed to do so. There is an administration that is supposed to do as a nation, we have not done. The administration of forensic testing. And by telling you want to go and charge terrorism, it's something like that. So he said, be in the Public Elections Act. Tomorrow, by the time you have brought it into the definition, election violence, in fact, the election violence or election offenses, they are well attached to the Public Elections Act. Whether you are the seat or not, you are those things are very, very clear. So for me, we should move them. And I think the age has been on serious, but what should maintain, and that's what it in the Constitution. When you are convicted, now we are not saying because we have to keep the six offenses. Let the new ones coming, they are stated, the rape and sexual conviction. Let it be treated in the Public Elections Act. So we can exhaust it extensively before taking decision. That's our offenses that in fact things that are bad in the context. So the most serious that we accepted. So that's what we are saying. So addendum to that, we can again review for every election the dynamics. We can review the election offenses and we brought it up to see what are the election offenses coming up as people. Let's don't like see as the other elections which have been every elections act.
Page 16, are we okay with page 16? 16. Page 16. Yes, Honorable Mustafa.
Still, 16 is a follow-up from 15. 3. In disqualification under subsection 2 shall end. A. 5 years after the sentence has been completed, or the person is pardoned.
We deleted all of those. We said all of the, in fact, the whole of page 16 and page 17. Why not? Okay, we maintain clause 17 downwards. So we only maintain, in fact, let's just debate on 17 and 18.
Clause 17.
No,
Speaker, before that.
Yeah. Yes, Mr. Minister.
Yes, so if I may, with only Mr. Speaker, still on criminal conduct. First, let's note that certain criminal conducts are listed in the Constitution, which will disqualify someone from serving as a member of Parliament. If you 76(1) D says if he has been convicted and sentenced for an offence which involves fraud or dishonesty. And then E, which we have proposed to delete now, says if he is under a sentence of death imposed on him any court, because we have now I'm just looking for the Constitution. Because we have abolished the death penalty. And then section 76 of the Constitution, subsection 2, says a person shall not be qualified for election to Parliament if he is convicted by any court of any offence connected with the election of members of Parliament. Mr. Speaker, I just want to add that we note the specificity on D, fraud or dishonesty. So now we can say corruption-related offences. But I just really want to go back to cabinet. The seriousness that cabinet attaches to persons who have been convicted for offences like treason, murder, manslaughter, rape or sexual penetration were particularly important to His Excellency and the rest of the members of cabinet. So my question would be that yes, there are broader offences, especially relating to, say, the provision said if someone has committed an offence for which they've served a sentence of 12 months, minimum 12 months, they will be disqualified. Is it possible to say yes, the proposal on 12-month sentence does not come into Constitution, but because the Constitution, the extant law is specific on fraud and dishonesty, and the seriousness that we attach to rape and sexual penetration, murder or manslaughter and treason, is it possible to keep these three categories of offences within the Constitution? Not two categories.
Yes, I think try to draw attention to 76. Now, if you look at 76, it's really limited in terms of offences. You don't mind carrying. I'm crossing from.
Yes. Yes.
76, Chairman. Let me read so that we can. First, we can talk about it. I've accepted the proposal for profession. But how do we deal with cases of potential penetration? How do we dishonesty? Let me dishonesty. Let me read 26. 26 D, let's start with D. We said if he has been convicted and sentenced for an offence which involves fraud or dishonesty. So for us, we can hold this one as the extant law, but in the public elections, we now this what are the things that support dishonesty? And fraud. What do we consider fraud and dishonesty? We have put it in the public elections as clear as day. That is one. And under offenses, what you have stated, we can run it up. Other issues that related to sexual penetration, even terrorism. The one that we need to remove is the death penalty. We don't need it anymore. Now, because they said we have amended death penalty. So we can really now give this conviction. Because it said if he is under a sentence of death, the normal person takes it. So we want to be consistent with what you have done. We are repealing the death penalty from the Constitution. Imposed on him or by any court. So we need not to have it. Chairman, are you with me? the death penalty should not stand.
The only thing is that I think you are all missing the point. This is something we deleted.
No, it got in fraud.
It's already in the public elections and in the constitution. I don't know why he is going back to it particularly.
But fraud is both fraud.
What is it on this one? Yeah, of course.
The E is gone.
Yes, everything is gone.
No, D is not gone. What he is saying, he wants us to maintain peace as a kingdom.
That one is already in the constitution.
Yes. So what when we come to public elections, we itemize them.
Okay, when we come to that, why don't we discuss this? We are taking this to the public elections. We need to label the point of this.
What do you
we should only deal with clause 17 and 18. Yes. 17 and 18.
Mr. Chairman, even 17 and 18, let's debate on that.
Yes.
About the issue of proportionality of the police and military, and we are very clear about the of course. So again, but I think here in 17, 18, the clause I was looking out for, the provision that will understand the Electoral Commission head is here, act in a partisan manner. I think we put it here for the police and military. So we can get that to the Chief Electoral Commissioner and act in a partisan manner.
Okay.
Thank you very much.
Mr. Chairman, I want you to give you feedback. Mr.
Speaker, I've conferred with the General Government Business and I'm going to propose that we are expunged and move to public elections act so that we can stay that way. Thank you.
Yes, thank you. So we are done. Mr. Minister, can you now move?
Mr. Speaker, Mr. Chairman, honorable members, I move that Part 1, clauses 1 to 18, stand part of the bill as amended.
Honorable members, the question is that parts 1, clauses 1 to 18 stand part of the bill as amended. All those in favor say aye. Aye. Those against say nay. The ayes are
Part 1, clauses 1 to 18 form part of the bill as amended. The House is yours.
There is the Minister report.
Mr. Speaker,
Hold on. You know what I mean? Let's go. Everything. Honorable Mara, please, Mara, please go. Honorable Mohamed Bangura, please come.
Honourable members, this sitting is stood down for 20 minutes. Please make sure, go fresh enough and come back in 20 minutes.
Viewers, we've just witnessed the amendment process on the Constitutional Amendment Bill 2025, which has successfully sailed through Part 1, pages 1 to 18, stood part of the bill, and has now sailed through Parliament for amendments.
motoka de wono